Before we begin, a quick and important disclaimer. This video is intended for educational and entertainment purposes, only regarding the financial and legal complexities of retirement account division during divorce. It does not constitute legal, tax, or financial advice. The laws surrounding 401k plans and qualified domestic relations orders vary significantly by state and individual circumstances. You should conduct your own due diligence and consult with a licensed professional, such as a family law attorney or a certified financial planner, before making any decisions regarding your personal finances or legal proceedings. Imagine working for 25 years at a single company, diligently contributing to your 401k every 2 weeks, skipping the luxury vacations, and choosing the reliable sedan over the sports car just to ensure your retirement was secure. You have watched your balance grow through market crashes and bull runs until it finally hits that 7-figure milestone. Then, in a single afternoon in a sterile courtroom, a judge signs a piece of paper that instantly transfers $500,000 of your life's work to someone else's name. This is not a horror story. It is the daily reality for thousands of Americans. In the United States, retirement accounts are often the single largest asset in a household, frequently surpassing even the equity in the family home. Yet, most people enter the divorce process with absolutely no understanding of how these funds are liquidated, divided, or taxed. We are currently witnessing a quiet catastrophe in American finance where the lack of preparation for a 401k split is leading to a generational wipeout of middle-class wealth. The economic impact of a 401k divorce is not just about losing half the money. It is about the structural destruction of compound interest and the sudden acceleration of tax liabilities that can haunt you for a decade. Today, we are initiating a deep dive masterclass into the mechanics of this crisis. We are going to solve the mystery of why your 401k is vulnerable, how the legal system views your personal savings, and the specific step-by-step pitfalls that cause people to lose an additional 30 to 40% of their remaining balance to the IRS and administrative fees during the transfer process. By the end of this series, you will understand the historical trends of retirement division and the potential outcomes of the most complex financial instrument in the American legal system. To understand the weight of this issue, we have to look at the sheer volume of capital at risk. As of the mid-2020s, Americans hold over $7 trillion in 401k plans. This is the backbone of the American dream, yet it is governed by a federal law from 1974 known as ERISA, or the Employee Retirement Income Security Act. This law was designed to protect your money from your employer and creditors, but it creates a massive legal hurdle when a marriage dissolves. Most people assume that because their name is the only one on the account, the money belongs to them. Historical trends in U.S. family law suggest otherwise. In the eyes of the court, any dollar contributed to that account from the day you said, "I do," until the day you file for divorce is considered marital property. It does not matter who earned the paycheck. It does not matter who managed the investment portfolio. The law views the marriage as an economic partnership, and the 401k is a joint venture. Let's look at a case study to illustrate the mathematical devastation of a poorly managed split. Consider a couple, whom we will call Sarah and David. David has a 401k valued at $800,000. They decide to divorce after 15 years. In an equitable distribution state, the court determines that Sarah is entitled to 50% of the marital portion of that account. David assumes he simply writes a check for $400,000. This is where the first layer of economic impact hits. You cannot simply withdraw money from a 401k to pay a spouse without triggering immediate consequences. If David withdraws the cash, he is hit with a 10% early withdrawal penalty if he is under age 59 and a half, plus federal and state income taxes. On a $400,000 withdrawal, he could easily lose $160,000 just to taxes and penalties, leaving Sarah with much less and leaving himself with a hollowed-out account. The solution used by the courts is something called a QDRO, or a Qualified Domestic Relations Order. This is a highly specialized legal document that instructs the plan administrator to split the account without triggering those penalties. However, the economic impact of the QDRO process itself is a significant drain. Most family law attorneys are not specialists in ERISA law. This leads to a secondary market of QDRO experts who charge thousands of dollars to draft a single document. If the document is rejected by the 401k plan administrator, which happens in a staggering number of cases due to minor clerical errors, the legal fees continue to mount, and the funds remain frozen. During this freeze period, which can last 6 to 18 months, the account holder often loses the ability to manage their investments. Imagine the market takes a sharp downturn while your 401k is in legal limbo. You cannot reallocate your assets or move to cash because the account is under a standing order from the court. This invisible economic impact can result in tens of thousands of dollars in market losses that neither spouse can prevent. This is the reality of the 401k divorce. It is a friction-filled process where value leaks out of the family unit at every stage. Furthermore, we must address the gray divorce trend. Statistics show that divorce rates for those over 50 have doubled since the 1990s. For this demographic, a 401k split is even more catastrophic because they lack the time horizon to recover. If you are 35 and you lose half your retirement, you have 30 years of compound interest to help you rebuild. If you are 60 and your $1 million nest egg is sliced in half, the math for a comfortable retirement simply no longer works. You are forced to choose between working an extra decade or drastically lowering your standard of living. This creates a ripple effect throughout the U.S. economy, as a massive cohort of seniors finds themselves with diminished purchasing power and a higher reliance on social safety nets. Another layer of this deep dive involves the tax time bomb, hidden within different types of retirement accounts. A common mistake in divorce negotiations is treating all dollars as equal. For example, if one spouse keeps the house with $400,000 in equity, and the other spouse keeps a 401k with $400,000 in it, they might think the split is equal. It is not. The house equity is often tax-free up to a certain limit upon sale, while every dollar in the 401k will be taxed as ordinary income when it is eventually withdrawn. This means the spouse with the 401k is actually receiving about 30% less in real spending power. This lack of financial literacy during the negotiation phase is one of the primary reasons why post-divorce poverty is a growing trend in the United States. As we move forward in this masterclass, we will break down the specific differences between community property and equitable distribution states, because where you live dictates the starting point of your financial destruction. We will analyze how separate property claims are made, such as when you started the 401k 5 years before the marriage, and why the burden of proof is on you to provide decades-old statements that most people have long since deleted. We will also explore the role of the plan administrator, the often ignored gatekeeper who has more power over your money than the judge or your attorney. This is part 1 of our 10-part deep dive into the economic impact of 401k divorce. We are moving beyond the surface-level advice you find on blog posts and getting into the raw mathematical truth of how wealth is transferred and lost in the American legal system. The goal here is clarity. By understanding the historical trends and the structural risks, you can better navigate the potential outcomes of a system that is designed to be difficult. We are going to look at the premarital trace, the valuation date traps, and the survivor benefit clauses that can take a bite out of your future even after your ex-spouse has passed away. The complexity is the point. The more complex the system, the more opportunities there are for your wealth to evaporate. We are here to ensure you see the trap before it snaps shut. To understand the true economic impact of a 401k split, we have to look at the geography of your wealth. In the United States, your financial destiny is often determined by the state line you live across. As of 2026, the legal framework for dividing retirement assets remains split between 2 primary systems: community property and equitable distribution. If you live in a community property state like California, Texas, or Arizona, the law is often a clinical mathematical exercise. Every dollar contributed to that 401k from the date of the marriage to the date of the separation is viewed as a joint asset, regardless of whose name is on the paycheck. The potential outcomes here are usually a rigid 50-50 split of the marital portion. While this sounds predictable, it creates a massive structural drain on the account holder's long-term compounding power. However, the majority of Americans live in equitable distribution states, such as New York, Florida, or Pennsylvania. In these jurisdictions, a judge has the discretion to divide assets in a way they deem fair, which does not always mean equal. This introduces a high level of economic uncertainty. A judge might look at a 20-year marriage where one spouse stayed home to raise children and decide that the spouse who worked is only entitled to 40% of their own 401k to compensate for the other spouse's lack of Social Security credits or career advancement. Historical trends in these states show that the legal fees associated with arguing over what is fair often consume a significant portion of the very asset being divided. You are essentially paying thousands of dollars to attorneys to debate the value of a retirement account that is simultaneously losing value due to market fluctuations and administrative holds. Imagine a scenario in 2026 involving a project manager named Mark. Mark has been at his firm since 2016 and married his spouse in 2020. Over that decade, his 401k grew from $0 to $500,000. When they file for divorce in 2026, Mark assumes that since he had the job for 4 years before the marriage, a large chunk of that money is his separate property. But here is the trap. The burden of proof is entirely on Mark. To protect that premarital portion, he must provide the plan statements from 2020 showing the exact balance on the day of the wedding. If Mark changed 401k providers or rolled his funds into a new employer's plan in 2023, those old records might be archived or difficult to access. If he cannot produce the paper trail, the court may default to treating the entire $500,000 as marital property. This is the traceability crisis, and it results in a massive unintentional transfer of wealth every single day in American courtrooms. The economic impact deepens when we consider the concept of active versus passive appreciation. Let's say Mark does prove he had $100,000 in the account on his wedding day. In many jurisdictions, the spouse is still entitled to 50% of the growth on that separate $100,000 because that growth occurred during the marriage. This is where the math becomes a nightmare. If the market performed well between 2020 and 2026, that original $100,000 might now be worth $180,000 due to market gains. Is that $80,000 of growth marital property or separate property? Some courts argue that if Mark made any active decisions, like rebalancing his portfolio or changing his investment elections, that growth is an active asset and therefore marital. This means that even the money you earned before you met your spouse is at risk of being diluted through the legal process. Then there is the issue of the 401k loan, a feature used by millions of Americans to fund home down payments or emergency expenses. In 2026, we are seeing a spike in 401k loan defaults during divorce proceedings. Imagine if Mark took out a $50,000 loan from his 401k in 2024 to renovate the family kitchen. During the divorce, that loan is considered a marital debt, but the mechanics of the 401k system do not care about the divorce. If Mark leaves his job or cannot keep up with the payments because his income is now split between two households, the loan is treated as a distribution. This triggers immediate federal income taxes and a 10% early withdrawal penalty if he is under 59.5. The economic impact is a double hit. He loses the $50,000 from his retirement nest egg, and he owes the IRS $15,000 to $20,000 in taxes and penalties right when he can least afford it. One of the most overlooked factors in this deep dive is the valuation date. In a volatile 2026 market, the date the court chooses to value the 401k can change the outcome by tens of thousands of dollars. If the court sets the valuation date as the day the divorce was filed, but the market crashes 3 months later while the lawyers are still drafting the paperwork, the account holder is stuck. They are legally obligated to pay their ex-spouse a dollar amount based on a high market value that no longer exists in the account. This creates a situation where the account holder might end up giving away 60 or 70% of their actual remaining balance, just to satisfy a court order based on an outdated number. This is the ghost equity problem, where you are paying out real dollars based on phantom gains. The administrative friction of the Qualified Domestic Relations Order, or QDRO, adds another layer of financial erosion. Most people think the judge's signature is the final step. In reality, it is just the beginning of a months-long administrative gauntlet. The QDRO must be sent to the 401k plan administrator, who acts as a secondary judge. These administrators often have their own specific, rigid requirements for how the document must be phrased. If a single comma is out of place or if the document uses the term balance instead of total vested account balance, the administrator can reject it. Each rejection means more billable hours for attorneys and QDRO specialists. While the document is being reviewed, the account is often placed under a legal hold. You cannot move your money, you cannot change your investments, and you cannot take a loan. You are essentially a passenger in your own financial life while the market moves around you. Consider the potential outcomes for a spouse who receives a portion of a 401k. For them, the economic impact is often a sudden, unexpected tax bill. If the receiving spouse decides to take their portion as a cash distribution, rather than rolling it over into their own IRA, the plan administrator is required by federal law to withhold 20% for federal taxes immediately. If that spouse is in a high tax bracket or lives in a state with high income tax, they could find that their $100,000 settlement quickly turns into $65,000 of actual cash. This is the net value illusion. People fight for years over a specific number, only to realize that the government is the silent third party in every divorce settlement. waiting to take its cut of the retirement pie. We also have to analyze the impact on employer matching. Many 401k plans have a vesting schedule. If you have been at your job for 3 years and your employer match is only 50% vested, the court has to decide how to value the unvested portion. Does the ex-spouse get a right to money that hasn't technically been earned yet? If the divorce decree says the spouse gets half of the account, and you get fired or quit before that match vests, you might be legally required to pay your ex-spouse out of your own pocket for money that the employer took back. This creates a hidden liability that can follow you long after the divorce is finalized. As we continue this masterclass, we have to look at the psychological and economic interplay of the house versus the 401k. In 2026, many couples are facing a choice. One person keeps the house, and the other keeps the retirement. On paper, if both are worth $400,000, it looks like a fair trade. But the house requires maintenance, property taxes, and insurance, while the 401k offers tax-deferred growth. Conversely, the house provides a roof over your head, while you cannot eat your 401k balance until you are 60. This trade-off is where many middle-class families make a mistake that leads to long-term poverty. We are going to look at the mathematical reality of why the person who keeps the 401k often ends up significantly wealthier 10 years later, even if the initial values were identical. But what happens when the 401k is not the only retirement asset? What if there is a pension, a 403b, or a deferred compensation plan involved? The rules change again, and the potential for error multiplies. In the next part, we are going to dive into the specific tax traps that the IRS has laid out for divorced couples, and how a single mistake in your filing status or your rollover timeline can trigger an audit that lasts for years. We will examine the specific language you need in your decree to avoid being taxed on money you never received. If you think the QDRO is complicated, wait until you see how the IRS handles the transfer of a 401k during a mid-year divorce. The tax man doesn't care about your settlement. He only cares about the code. How do you ensure you are not the one left holding the bill for your ex-spouse share? We will break that down next. The IRS does not see a divorce as a tragedy. It sees it as a taxable event. To understand how the tax man handles your 401k during a split, we have to look at the specific language of the Internal Revenue Code, specifically Section 402(1)(a). This section is the only reason why a 401k transfer doesn't immediately result in a massive tax bill for the person who earned the money. It essentially states that if a 401k is divided via a qualified domestic relations order, the ex-spouse, legally referred to as the alternate payee, is treated as the distributee. This means the tax liability follows the money. If your ex-spouse receives $500,000 from your account and decides to spend it on a new home in 2026, they are the ones responsible for the income tax, not you. However, this protection is fragile, and the potential outcomes for those who fail to follow the strict procedural timeline are financially devastating. Imagine a scenario in 2026 involving a software engineer named Michael. Michael has a 401k worth $900,000. As part of his settlement, his ex-spouse, Jennifer, is awarded $400,000. Michael, wanting to be done with the process, simply goes into his HR portal and requests a distribution check for $400,000 made out to Jennifer. This is a catastrophic error, because this distribution was not processed through a formal QDRO approved by the plan administrator. The IRS views this as Michael taking a personal withdrawal and then gifting the money to his ex-wife. The historical trends in tax court are clear. The IRS will issue Michael a 1099-R. Michael will now owe federal and state income taxes on that $400,000, likely pushing him into the highest tax bracket. Furthermore, since Michael is only 45, he is hit with a 10% early withdrawal penalty. Michael just lost nearly $200,000 to the government for a mistake that took 5 minutes to make. The only way to avoid this is through the meticulous execution of a QDRO before any money moves. But even with a QDRO, there is a specific high-stakes choice that the alternate payee must make. And this is where the economic impact becomes a strategic game. Under Section 72(2)(c) of the tax code, there is a unique exception for QDROs. Normally, if you are under age 59 and a half, any money you take out of a 401k is subject to that 10% penalty. However, if an ex-spouse receives money via QDRO, they can choose to take a cash distribution directly from the 401k provider, and the 10% penalty is waived. They still owe income tax, but the penalty is gone. This creates a massive one-time only financial opportunity. If Jennifer, Michael's ex-wife, needs cash for a down payment on a house in 2026, she should take it directly from the 401k at the time of the QDRO transfer. If she instead rolls that money over into her own individual retirement account (IRA), and then tries to take the cash out a month later, the QDRO protection evaporates. Once the money touches an IRA, it is governed by IRA rules, which do not have the same 10% penalty exception for divorce. This mistake happens in thousands of divorces every year. Spouses roll over the money first, then realize they need cash, and end up paying a 10% ignorance tax to the IRS. We must also look at the mandatory 20% withholding rule. By federal law, if a 401k provider issues a check directly to an alternate payee instead of doing a direct rollover to another retirement account, they are required to withhold 20% for federal taxes immediately. Imagine if Jennifer was counting on that full $400,000 to buy a property. She receives the check, but it is only for $320,000. The other $80,000 is sitting with the IRS. If her actual tax bracket is 32%, she will owe even more come April. This liquidity crunch can derail a post-divorce financial plan before it even begins. This is why the direct rollover is the gold standard for preserving wealth during a 401k split. The 2026 tax landscape adds another layer of complexity. With the potential sunsetting of various tax provisions from previous years, the timing of when a divorce is finalized can change your tax bracket significantly. In the eyes of the IRS, your marital status on December 31st is your status for the entire year. If Michael and Jennifer finalize their divorce on December 30th, 2026, they both must file as single or head of household for the entire year of 2026. If Michael was the high earner, his tax bill might skyrocket because he can no longer leverage the wider tax brackets of a joint return. This single penalty can cost a high-earning professional an extra $10,000 to $15,000 in a single year, an economic impact that is rarely discussed in the lawyer's office but felt deeply in the bank account. Case studies also show a recurring nightmare involving the 1099-R form. This is the document the 401k provider sends to the IRS to report the distribution. If the QDRO is not coded correctly by the plan administrator, the 1099-R might be issued in the name of the original account holder, Michael, even if the money went to Jennifer. Now Michael has to prove to the IRS that he shouldn't be taxed on that $400,000. This usually requires a professional tax resolution expert and months of correspondence with the IRS. To prevent this, your QDRO must explicitly state that the alternate payee is responsible for all tax consequences associated with their distribution. Then there is the issue of after-tax contributions. Not all $401,000 are the same. Some employees make non-Roth after-tax contributions to their plans. These are dollars that have already been taxed but grow tax-deferred. During a divorce, these basis dollars are incredibly valuable because they can be withdrawn tax-free. If your 401k has a mix of pre-tax and after-tax money, how do you divide it? If the QDRO says Jennifer gets 50% of the account, does she get 50% of the pre-tax and 50% of the after-tax? Or can Michael negotiate to keep all the after-tax basis for himself? If the records from 2020 or 2022 are missing, the 401k provider will often default to assuming the entire account is pre-tax, essentially vaporizing the tax-free benefit of those after-tax contributions. This is a step-by-step failure of record-keeping that results in the IRS getting a second bite of the same apple. We also have to consider the 60-day rule trap. If a spouse receives a distribution check from a 401k with the intent to roll it into an IRA, they have exactly 60 days to complete that deposit. If they miss that window by even one day, perhaps because of the chaos of moving or a delay in opening a new account, the entire amount becomes taxable income. In 2026, the IRS has become increasingly strict about granting waivers for the 60-day rule. If you are dealing with a $100,000 transfer, a simple administrative delay can result in a $30,000 tax bill. The economic impact of a 401k divorce is essentially a war of attrition against tax codes and administrative timelines. Every step of the way, there is a mechanism designed to capture a portion of your wealth for the government. Whether it is the mandatory withholding, the 10% penalty, or the shifting tax brackets of a newly single filer, the real value of a 401k is always much lower than the number on the statement. Understanding these potential outcomes is the only way to build a settlement that actually provides the financial security you think you are getting. But taxes are just the beginning of the erosion. What happens when the market moves while the lawyers are arguing? What if your 401k is invested in high-risk tech stocks, and the market drops 20% the week before the transfer happens? Who bears that loss? And what about the specific investments themselves? You cannot just split a share of a mutual fund in half without selling it first. The hidden costs of liquidation and the market timing risks of a QDRO transfer can be just as damaging as the IRS. In the next part, we are going to dive into the volatile valuation crisis. We will look at how to protect yourself from a market crash during your divorce, and why the earnings and losses clause in your QDRO is the most important sentence you will ever sign. If that sentence is missing, you could be paying your ex-spouse money that no longer exists. We will break down the math of the market slide next. The math of the market slide begins with a single, often overlooked line in your divorce decree: the valuation date. In the volatile financial landscape of 2026, where market swings of 3 to 5% in a single week have become a common historical trend, the gap between the day you agree on a number and the day the money actually moves is a financial minefield. Most people assume that if they agree to give their spouse $100,000 from their 401k, that is the end of the conversation. In reality, you are entering a period of extreme market timing risk that can last anywhere from 90 days to 6 months, while the paperwork clears the administrative hurdles. Imagine a case study involving a tech lead named Robert. It is early 2026, and Robert has a 401k valued at $800,000, heavily weighted in high-growth equities that have performed exceptionally well over the last decade. During mediation, Robert and his spouse, Sarah, agreed to a 50-50 split. They sign a settlement agreement stating that Sarah is to receive $400,000. This sounds simple, but they have just created a fixed dollar award. This is one of the most dangerous potential outcomes in a 401k divorce. While the lawyers are drafting the qualified domestic relations order, and the plan administrator is performing their mandatory 60-day review, the market experiences a sharp correction. Robert's $800,000 account drops by 25%, leaving him with $600,000. Because the legal document specifies a fixed dollar amount of $400,000 for Sarah, the plan administrator is legally obligated to fulfill that specific number. When the transfer finally happens, Sarah gets her $400,000, but Robert is left with only $200,000. He didn't just lose half. He lost 75% of his wealth because he failed to account for the market slide. This is why the earnings and losses clause is the most critical component of a masterclass in 401k division. A properly drafted QDRO should specify whether the alternate payee's share will be adjusted for market fluctuations between the valuation date and the date of actual distribution. If Robert's attorney had included a clause stating that Sarah's 50% share would be adjusted for pro rata earnings and losses, the impact of the market crash would have been shared. In that scenario, Sarah would have received $300,000, and Robert would have kept $300,000. The failure to include this single sentence is a primary driver of post-divorce financial ruin for the primary account holder. The complexity deepens when we look at the mechanics of how these funds are actually moved. Once a plan administrator receives a certified copy of the QDRO, they typically initiate what is known as a segregated account. This is a shadow account where the spouse's portion is moved, while the final details are processed. However, there is often a blackout period during this transition. During this time, which can last several weeks, neither the original account holder nor the alternate payee has the ability to trade or reallocate assets. You are essentially frozen in your positions. In a year like 2026, characterized by rapid sector rotations and geopolitical volatility, being unable to move your money to more stable assets like money market funds can result in a massive loss of purchasing power. Step by step, the administrative friction looks like this. First, the court signs the order. Second, the order is mailed to the plan administrator. Third, the administrator places a hold on the entire account, preventing any withdrawals or loans. Fourth, the administrator determines if the order is qualified. If it is, they calculate the award based on the valuation date. Fifth, they sell the necessary shares to create the cash or transferred units for the alternate payee. This fifth step is where the market slide math becomes real. If the market is down when those shares are sold, you are locking in a loss that can never be recovered. Historical trends show that many 401k plans do not allow for the transfer of actual shares or fund units to an ex-spouse. Instead, they require a liquidation of the assets followed by a cash transfer to a new account. This creates a hidden transaction cost. If you have a large position in a proprietary institutional fund that has no retail equivalent, you are forced to sell at the current market price, pay any applicable administrative fees, and then your spouse has to find a new place to invest that cash. The bid-ask spread and the time out of the market can easily erode another 1 to 2% of the total account value. We must also consider the impact of dividends and interest. If the 401k is invested in dividend-paying stocks or bond funds, who gets the income generated during the months of legal processing? If your QDRO only mentions the principal balance, the account holder might end up keeping thousands of dollars in dividends that the other spouse expected to receive. Conversely, if the order says the spouse gets all interest and dividends, the account holder might find their remaining balance is lower than they projected. In 2026, with interest rates remaining a key factor in retirement planning, these small percentages add up to significant real-world dollars. Another critical factor is the loan balance adjustment. Many Americans in 2026 carry active loans against their 401k. When calculating the split, many people make the mistake of using the net balance. For example, if Robert has $500,000 in his account but a $50,000 loan, the statement might show a total value of $500,000. However, Sarah's attorney might argue for 50% of the gross value, ignoring the debt. If the QDRO is not explicit about whether the loan is included or excluded from the marital pot, the account holder could end up effectively paying off the entire marital loan with their half of the retirement funds. This is a common mathematical trap that can swing the final settlement by tens of thousands of dollars. To add more value, we have to look at the inflationary impact of these delays. In the current economic climate, $1 today is not worth $1 6 months from now. If the divorce process drags on for a year, the purchasing power of that retirement account is being eroded by inflation, while it is simultaneously being attacked by legal fees and market volatility. This is why high-net-worth individuals often use a strategy called a partial QDRO or a preliminary distribution to move a portion of the funds early. But this requires a high level of legal sophistication and cooperation between parties that is often missing in contested divorces. The economic impact of the 401k divorce is ultimately a lesson in the fragility of paper wealth. Your 401k statement is a snapshot in time, but the legal process of dividing it is a slow-motion video. If you do not align the snapshot with the video through precise legal language, the discrepancy will always be settled at your expense. We have seen cases where people thought they were financially secure, only to realize that the combination of a market dip and a missing earnings and losses clause left them with 40% less than they had calculated on their divorce spreadsheet. But market volatility is not the only invisible hand reaching into your retirement. There is also the issue of the 401k provider's own internal rules. Every company has a summary plan description, a document that most people never read, which contains the specific laws of that 401k. Some plans charge a flat fee of $500 to $1,000 just to review a QDRO. Others charge a percentage of the assets being moved. Who pays those fees? If the decree doesn't say, the plan might default to taking it out of the original account holder's share. As we move deeper into this masterclass, we have to talk about the ultimate endgame. What happens once the money is finally in the ex-spouse's name? There is a massive multi-billion-dollar industry waiting to capture those new retirement dollars, and the advice they give can lead to even more economic erosion. We are going to look at the rollover trap, and how certain investment vehicles can lock your money away with even more restrictions than the original 401k. We will also examine the survivor benefit crisis. What happens if you or your ex-spouse passes away before the money is moved? If you don't have the qualified pre-retirement survivor annuity clause in your paperwork, the money you fought for could vanish into the plan's general fund. We will break down the life and death clauses next. The life and death clauses are where the theoretical division of assets meets the cold, hard reality of human mortality. Most Americans navigating a 401k divorce in 2026 focus entirely on the number at the bottom of the statement, but they fail to account for the gap of time between the day the judge signs the divorce decree and the day the plan administrator actually moves the funds. This period is known as the dead zone. Historically, this gap can last anywhere from 6 weeks to 6 months, depending on the efficiency of the legal teams and the complexity of the 401k plan's requirements. If either the account holder or the ex-spouse passes away during this window, the economic impact can be a total loss of the retirement asset for one party, resulting in a massive, unintended windfall for another. To understand the stakes, we must look at the Qualified Pre-Retirement Survivor Annuity, or QPSA. Under the Employee Retirement Income Security Act, or ERISA, every 401k plan is required to provide a survivor benefit to the spouse of a participant. When you are married, this protection is automatic. However, the moment the divorce decree is signed, you are no longer a spouse. If the participant dies the next day, and the Qualified Domestic Relations Order or QDRO has not been finalized and accepted by the plan, the ex-spouse may have zero legal claim to the survivor benefits. In this scenario, the money doesn't just sit there. It is often paid out to whoever was listed as the beneficiary on a form signed 20 years ago, which might be a sibling, an old friend, or even a previous partner. Imagine a case study in 2026 involving a senior architect named James. James has a 401k valued at $1.2 million. He and his wife of 25 years, Linda, finalized their divorce in March. The settlement awards Linda 60% of the account to compensate for her years out of the workforce. James, being a busy professional, delays the final submission of the QDRO paperwork. In April, James suffers a fatal heart attack. Because the divorce was finalized, Linda is no longer his legal spouse. However, because the QDRO was not yet qualified by the plan administrator, the plan defaults to the beneficiary designation on file. James had never updated his beneficiary since he started the job in 1998, listing his younger brother as the sole beneficiary. Despite 25 years of marriage and a signed court order, the $1.2 million is paid in its entirety to James's brother. Linda, at age 60, is left with nothing. This is not a hypothetical outlier. It is a recurring historical trend in the American legal system where federal law ERISA trumps state-level divorce decrees. The economic impact of this situation is often a multi-year legal battle that drains what little assets remain. Linda's only hope would be to seek a nunc pro tunc order from the court. This is a Latin term meaning now for then. It is a specialized legal move where a judge signs the QDRO after the participant's death, but backdates it to a time before the death occurred. In 2026, many 401k plan administrators have become increasingly aggressive in fighting these orders to avoid paying out benefits to an ex-spouse when they have already paid a named beneficiary. The legal fees for a nunc pro tunc battle can easily exceed $50,000, and there is no historical trend that suggests a high success rate once the funds have already been distributed. Now, consider the opposite risk. What if the person receiving the money, the alternate payee, passes away before the transfer is complete? This is where the concept of the successor alternate payee becomes vital. If Linda had been the one to pass away in April before the $1.2 million was split, her estate might receive nothing if the QDRO was not properly drafted. Most standard QDRO templates provided by 401k plans do not include a provision for what happens if the alternate payee dies. Without specific language naming Linda's children or her estate as the successor, the money stays in James's account. For Linda's heirs, this represents a $720,000 loss of their mother's life work and their own inheritance. To prevent this, a masterclass level of drafting is required, ensuring that the order specifically states that the right to the funds is vested and survives the death of the alternate payee. We also have to analyze the Qualified Joint and Survivor Annuity, or QJSA, which is common in older 401k plans that have a pension-like component. If a participant has already retired and is receiving monthly payments, those payments are typically structured based on the joint lives of the couple. During a divorce, if you do not specifically address the QJSA in the settlement, the original spouse remains the beneficiary of the survivor annuity, even if the participant remarries. This creates a secondary economic impact where a new spouse is left with no retirement income upon the participant's death, because the ex-spouse from 30 years ago still holds the survivor rights. In 2026, as the baby boomer generation continues to navigate late-life divorces, the overlap of multiple marriages and surviving annuity rights is creating a logistical and financial nightmare for plan administrators and families alike. The step-by-step detail for protecting yourself from these life and death traps is rigid. First, your divorce decree must explicitly state that the ex-spouse shall be treated as the surviving spouse for purposes of all survivor benefits under the plan. Second, you must secure a joinder, which is a legal process that joins the 401k plan as a party to the divorce, essentially putting them on notice that a claim is pending. Third, you must ensure the QDRO is drafted, served, and qualified as quickly as possible. Every day of delay is a day you are gambling with the entire value of the asset. Furthermore, we must address the 2026 perspective on beneficiary designations. In the landmark case of Kennedy versus Plan Administrator for DuPont Savings and Investment Plan, the U.S. Supreme Court ruled that a plan administrator is generally required to follow the beneficiary designation on file, even if the ex-spouse signed a waiver in the divorce decree. This means that if you are the one with the 401k, you cannot rely on your divorce papers to protect your money. You must manually update your beneficiary forms with your HR department immediately. If you fail to do this and you pass away, your ex-spouse could legally collect your entire 401k, and your current family or children would have almost no recourse in federal court. This is the ultimate economic irony. The person you just spent thousands of dollars to divorce ends up with 100% of your retirement because of a single missing signature on a digital portal. The historical trends of these failures suggest a lack of coordination between family law attorneys and retirement specialists. A family lawyer understands the split, but they often do not understand the ERISA requirements for survivor benefits. This gap in expertise is where wealth evaporates. In our 2026 economic environment, where every dollar is vital due to inflation and shifting Social Security projections, losing a 401k to a death trap clause is a catastrophe that can lead to immediate poverty for the surviving party. We are seeing an increase in professional liability lawsuits against attorneys who fail to advise their clients on these specific risks, but a lawsuit takes years and won't put food on the table next month. The depth of this issue extends to the tax treatment of death benefits. If an ex-spouse does successfully receive the funds after the participant's death, they are no longer receiving them as a divorce transfer, but as a death benefit. This can trigger the 10-year rule under the Secure Act, which requires all funds to be withdrawn and taxed within 10 years of the participant's death. This is a much more aggressive tax schedule than a standard rollover, potentially forcing the ex-spouse into higher tax brackets and significantly reducing the net economic value of the settlement. But death is not the only way the legal process can fail you. Even if everyone stays healthy, there is a hidden mechanism within the 401k system that can drain your account through administrative fees and hidden transaction costs. What happens when the 401k company itself charges you for the privilege of dividing your money? And how do you handle the specific investments that cannot be easily split? In the next part, we are going to dive into the administrative fee crisis. We will look at how 401k providers are quietly taking a cut of your settlement and how to negotiate who pays the bill. We will also examine the complexities of non-traditional assets within a 401k, like company stock or stable value funds, that can become illiquid exactly when you need them most. We will break down the fee structures and the illiquidity traps next. The administrative fee crisis is the invisible toll booth on the highway to financial separation. In 2026, the process of dividing a 401k is no longer a simple internal adjustment handled by a friendly HR representative. Most major American corporations have outsourced their retirement plan administration to massive third-party providers. These entities view the processing of a qualified domestic relations order as a high-liability manual task, and they price it accordingly. When you submit a QDRO for review, you are often entering a fee structure that can siphon off thousands of dollars before a single cent is transferred to your ex-spouse. Imagine a case study involving Marcus, a senior engineer at a large aerospace firm. Marcus has a 401k balance of $600,000. In his divorce settlement with Elena, they agree to an equal split. However, their legal team fails to specify who bears the administrative costs of the QDRO. When the paperwork is submitted to the plan administrator, a $1,200 review fee is triggered. Because the decree was silent on this cost, the administrator follows the historical trend of deducting the fee from the total account balance before the split. While $1,200 might seem negligible in a $600,000 account, it is only the first of many such deductions. If the QDRO is rejected for a minor technicality, such as a missing zip code or a slight mismatch in the employer's legal name, the fee is often charged again for the re-review. In 2026, some administrators have moved to a tiered pricing model where the complexity of the investment portfolio dictates the fee, meaning Marcus could lose several $1,000s just to get the plan's stamp of approval. The economic impact deepens significantly when we look at the illiquidity traps within modern 401k plans. Many Americans in 2026 have followed the advice of the last decade and diversified their retirement savings into stable value funds or institutional real estate investment trusts, known as REITs. These assets are designed to provide steady returns and low volatility, but they come with a hidden danger during a divorce: exit restrictions. A stable value fund often employs what is known as an equity wash rule, or a 12-month put option. This means that if you want to move money out of the fund, the plan can legally delay that transfer for up to a year to protect the fund's liquidity. Imagine if Marcus had $200,000 of his balance in a stable value fund. If the QDRO mandates an immediate transfer to Elena, but the fund triggers a 12-month delay. Marcus is stuck. He cannot fulfill the court order, and he may be held in contempt of court or forced to pay Elena from his liquid cash savings to compensate for the delay. The historical trends of these funds suggest that during periods of market stress, which we are seeing in 2026, these exit gates are locked tighter than ever. This creates a situation where the account holder is legally obligated to pay money that is physically impossible to move, leading to additional legal fees as attorneys fight over the delay. Furthermore, we must address the company stock trap. Many 401k plans in the United States offer a company stock fund, where employees can invest in their own employer. This often leads to a concept called net unrealized appreciation, or NUA. This is a sophisticated tax strategy where, if you take a lump sum distribution of company stock, you only pay ordinary income tax on the cost basis of the shares, while the growth is taxed at the much lower long-term capital gains rate. However, a 401k divorce can vaporize this potential outcome. If the QDRO requires the plan to sell the shares to facilitate a cash transfer to the ex-spouse, the NUA benefit is destroyed for that portion of the stock. In our case study, if Marcus has $100,000 in company stock with a cost basis of only $10,000, he is sitting on $90,000 of growth that could be taxed at 15% or 20% instead of his 35% income tax bracket. If the divorce settlement forces a liquidation of half that stock to pay Elena, Marcus has effectively agreed to a massive, unnecessary tax hit. The economic impact here is not just the loss of the money, but the loss of the tax-efficient vehicle that would have protected that money for decades. Step by step, the failure to negotiate a transfer in kind of these shares can cost a high earner tens of thousands of dollars in future tax liabilities. We also have to consider the administrative freeze that occurs during the QDRO review period. Once the plan administrator receives a draft QDRO, they typically place a total hold on the account. In 2026, with the market experiencing rapid fluctuations, this freeze is a high-stakes gamble. For a period of 60 to 90 days, the participant cannot rebalance their portfolio, change their contribution rates, or execute any trades. If a major economic event occurs and the tech sector, where Marcus's funds are concentrated, drops by 15%, he is forced to watch his net worth evaporate with no ability to move to cash or bonds. This invisible cost of the divorce process is never listed on a lawyer's bill, but for a six-figure account, a 15% drop during a freeze represents a $90,000 loss that neither party can recover. Then there is the issue of fractional shares and unvested assets. Many 401k plans involve complex vesting schedules where the employer's matching contributions only become the employee's property after 5 or 6 years of service. If a divorce occurs while a portion of the 401k is unvested, the court must decide how to value that potential money. If the QDRO awards the ex-spouse 50% of the account, does that include 50% of the unvested portion? If Marcus is laid off in late 2026 before those funds vest, he may still be on the hook to pay Elena her share of money that he never actually received. This creates a phantom debt that can cripple a person's post-divorce recovery. To add even more value to this deep dive, we have to look at the role of professional QDRO preparers. Because attorneys often fear the liability of ERISA law, they frequently outsource the drafting of the QDRO to specialized firms. These firms charge their own fees, often ranging from $500 to $2,000 per document. If the 401k plan is a multi-employer plan or involves a combination of a 401k and a pension, you may need multiple QDROs, each with its own set of fees. In a contested divorce where the parties cannot agree on the specific wording of the order, these preparers can end up drafting 3 or 4 versions, each one eating away at the marital estate. The cumulative economic impact of these fees, liquidity traps, and tax losses is what we call the friction of the split. Most people calculate their divorce settlement based on the gross numbers, but after the plan administrator takes their cut, the stable value fund locks the gates, and the NUA tax benefits are lost. The actual net value of the settlement can be 20% to 30% lower than expected. In 2026, as Americans deal with tighter credit markets and higher costs of living, this 30% gap is the difference between a secure retirement and a desperate one. Understanding these mechanics is the only way to protect what you have built. You must ask the right questions. Does the plan allow for in-kind transfers of stock? What is the specific fee for QDRO review, and who is paying it? Are there exit restrictions on the stable value funds? Failure to address these details in the settlement agreement means the plan administrator will make the decisions for you, and historical trends show that those decisions are rarely in the participant's financial favor. But the 401k is only one piece of the puzzle. What happens when you factor in the other pillar of American retirement, Social Security? There is a massive, misunderstood interaction between your 401k settlement and your future Social Security benefits, particularly if you are part of a government pension system. In the next part, we are going to dive into the Social Security offset and the windfall elimination provision. We will look at how your 401k divorce can unexpectedly trigger a reduction in your monthly Social Security checks, and how the 10-year rule for marriage can change your entire strategy for filing. We will break down the interaction between federal benefits and private savings next. The intersection of Social Security and the 401k is where federal law and state divorce courts often collide, creating a complex financial puzzle that can leave one spouse significantly poorer than they anticipated. To understand the economic impact of a 401k divorce in 2026, we have to address the elephant in the room. Social Security benefits cannot be divided by a state court judge. Under the Social Security Act, these benefits are non-transferable and non-assignable. However, while a judge cannot touch your Social Security check, they can, and often do, adjust the distribution of your 401k to compensate for the disparity in future federal benefits. This is a concept known as the Social Security offset, and it is a major driver of wealth redistribution in modern American divorces. Imagine a case study involving Susan and Gary, a couple in their late 50s finalizing their divorce in 2026. Susan has spent 20 years as a high-earning marketing executive with a 401k currently valued at $800,000. She has also paid the maximum into Social Security for 2 decades. Gary, on the other hand, worked as a public school teacher in a state where he did not pay into Social Security but instead contributed to a state pension system. When they sit down to divide the 401k, Gary's legal team brings up a powerful argument based on historical trends in equitable distribution. They argue that because Gary will not receive a significant Social Security benefit, while Susan is on track for a maximum monthly payment, it would be unfair to split the 401k 50-50. The court may decide to value Susan's future Social Security stream as a present-day asset. Using actuarial tables and a discount rate, an expert might determine that Susan's Social Security is worth $400,000 in today's money. To make the total marital pot equitable, the judge might award Gary an extra $200,000 of Susan's 401k to offset his lack of Social Security. The potential outcome here is that Susan keeps only $200,000 of her $800,000 401k, while Gary walks away with $600,000. Susan is left with a hollowed-out retirement account, relying entirely on a government benefit that is subject to legislative changes, while Gary has liquid, investable cash in a 401k. This is the hidden math that destroys 401k balances before the ink on the divorce decree is even dry. The 10-year rule for Social Security is the critical threshold that every divorcing couple in 2026 needs to understand. To be eligible to collect a spousal benefit based on an ex-spouse earnings record, the marriage must have lasted at least 10 years. If you divorce at 9 years and 11 months, you lose the lifetime right to claim up to 50% of your ex-spouse's primary insurance amount. This creates a massive economic incentive to delay the finalization of a divorce. In our 2026 landscape, we see many couples engaging in what is essentially a Cold War, dragging out legal proceedings just to cross that 10-year finish line. Imagine if Gary and Susan were at 9 years of marriage. If Susan pushes for a quick divorce, Gary loses a benefit that could be worth hundreds of thousands of dollars over his lifetime. To compensate for this loss, Gary might demand a much larger share of the 401k right now. The negotiation becomes a trade-off between a certain current asset, the 401k, and an uncertain future benefit, Social Security. Historically, the person who keeps the $401,000 often fares better because those dollars can be invested and grown, whereas Social Security is a fixed formula. However, for the spouse with the 401k, the pressure to give up a larger percentage to settle the case and avoid the 10-year mark can lead to a significant depletion of their immediate net worth. We also have to dive deep into the windfall elimination provision, or WEP, and the government pension offset, or GPO. These are two of the most misunderstood federal rules that impact 401k holders who also have public sector experience. If you have a 401k from a private sector job, but you also earned a pension from a government job where you didn't pay Social Security taxes, the WEP can significantly reduce your own Social Security benefit. In a divorce, if your 401k is being split based on the assumption that you will have a full Social Security check, but the WEP is going to slash that check by 40 or 50%, you are being double taxed by the legal system. Your 401k is being depleted to offset a Social Security benefit that you aren't actually going to receive in full. Step by step, the calculation of these offsets is a specialized field. First, a vocational or actuarial expert is hired to project both spouses' Social Security benefits at full retirement age. Second, they calculate the present value of those benefits, which involves complex formulas using current 2026 interest rates and life expectancy data. Third, they compare these values to the current 401k balance. This process itself costs thousands of dollars in expert witness fees, which is another direct economic drain on the marital estate. For a middle-class couple with a $500,000 401k, spending $20,000 on experts just to argue about Social Security offsets is a net loss for the family unit. There is also the inflation factor to consider. Social Security benefits are adjusted for inflation through cost of living adjustments, or COLAs. In 2026, as we deal with the long-term effects of recent inflationary cycles, the value of a COLA-protected benefit is incredibly high. A 401k has no such guarantee. If you trade away a larger portion of your 401k to your spouse because they aren't getting Social Security, you are giving up an asset that you must manage against market risk and inflation, while they receive a shadow value that is essentially gold-plated. Historical trends suggest that attorneys often undervalue the inflation protection aspect of Social Security when negotiating 401k splits, leading to a raw deal for the 401k holder. Furthermore, we must look at the remarriage trap. If an ex-spouse who is collecting a portion of your 401k decides to remarry before age 60, they may lose their eligibility for Social Security benefits based on your record. However, the money they took from your 401k via QDRO is theirs forever. They don't have to give it back. This creates an asymmetric risk. You have lost your 401k forever, but the justification for that loss, their need for retirement security because they don't have their own Social Security, might vanish the moment they walk down the aisle with a new wealthy partner. This is why some 2026 settlement agreements are starting to include reopener clauses or complex alimony structures instead of a flat 401k split, but these are difficult to enforce and often lead to more litigation. The economic impact is also felt in the timing of the claims. If you are divorced, you can claim benefits on your ex-spouse record even if they haven't retired yet, as long as you have been divorced for at least 2 years and you are both at least age 62. This is a massive shift from the rules for married couples, where one spouse usually has to file before the other can claim a spousal benefit. For the 401k holder, this means their work history is being leveraged by an ex-partner while they themselves are still working and contributing to their 401k. It doesn't reduce your check, but it highlights the reality that your career is a resource that continues to be harvested long after the marriage ends. Ultimately, the 401k and Social Security are the two pillars of the American retirement bridge. When one pillar is cracked by a divorce, the other must bear more weight. If you do not understand the interaction between the two, you are likely to build a bridge that collapses the moment you try to cross it into retirement. We are seeing a generation of divorced Americans reaching their 60s only to realize that the fair split they agreed to a decade ago didn't account for the reality of Social Security rules, leaving them with a 401k that is too small and a federal benefit that is smaller than expected. But what if you aren't just splitting the account today? What if you are being asked to pay alimony out of your 401k? Or what if your 401k is being used as collateral for other marital debts? The 401k is often the lender of last resort in a messy divorce, and the long-term cost of using retirement funds to solve today's cash flow problems is staggering. In the next part, we are going to dive into the liquidity trap. We will look at how 401k funds are being used to pay for legal fees, alimony, and child support, and the exact mathematical reason why a dollar taken out of your 401k at age 45 costs you $10 by age 65. We will break down the compounding catastrophe of the early withdrawal next. The compounding catastrophe begins with a fundamental misunderstanding of what a dollar in your 401k actually represents. It is not just currency, it is a seed. In the high-stakes environment of 2026, where the cost of living continues to climb and the Social Security landscape remains uncertain, the decision to use your retirement account as a piggy bank to settle a divorce is the financial equivalent of eating your own seed corn. To understand the economic impact, we must look at the math of opportunity cost, which is the silent killer of American wealth. Imagine a case study involving a 45-year-old manager named Brian. Brian has spent 20 years building a 401k balance of $500,000. In his 2026 divorce settlement, he faces a common dilemma. His ex-spouse is entitled to half of the marital assets, but the only liquid assets they have are the equity in the family home and the 401k. To keep the house and avoid uprooting his children, Brian agrees to give his ex-spouse $250,000 from his retirement account via a qualified domestic relations order. At first glance, Brian thinks he has won. He kept the house. He has $250,000 left in his 401k. He assumes he can just work a little harder and catch up. The historical trends of the market suggest Brian is tragically mistaken. To see the true economic impact, we apply the rule of 72. If we assume a conservative historical average return of 7%, an investment doubles every 10 years. If Brian had left that $250,000 in his account, it would have grown to $500,000 by age 55 and $1 million by age 65. By giving away that money at age 45, Brian hasn't just lost $250,000. He has signed away $750,000 of his future purchasing power. This is the compounding catastrophe. Every dollar removed today is $10 lost at the finish line. But the situation is often worse than a simple QDRO transfer. Let's imagine another 2026 scenario where Brian's divorce becomes litigious. He owes $50,000 in legal fees and another $20,000 in a lump sum alimony payment. Short on cash, he decides to take a hardship withdrawal or a non-qualified distribution from his 401k. This is where the IRS and the liquidity trap tighten their grip. Because this is not a direct rollover or a QDRO sanctioned transfer to an ex-spouse, Brian is hit with a 10% early withdrawal penalty. On a $70,000 withdrawal, that is $7,000 gone immediately. Next comes the federal and state income tax. In 2026, Brian is in a 24% federal bracket and a 5% state bracket. Another $20,300 is vaporized. To get $70,000 in his pocket to pay his bills, Brian actually had to withdraw nearly $98,000 from his 401k. He has essentially paid a 40% tax on his own money just to access it. When you factor in the loss compounding on that $98,000 over the next 20 years, the true cost of that $70,000 legal bill is nearly $400,000 in lost retirement wealth. The economic impact of using a 401k for immediate divorce expenses is a form of financial self-cannibalization that most people do not fully grasp until they reach their 60s and realize their account balance is decades behind where it should be. Furthermore, we have to look at the rebuilding phase. In 2026, the IRS limits for 401k contributions are strictly capped. Even with catch-up contributions for those over 50, there is a physical limit to how much you can put back into the system. If Brian loses $250,000 in a divorce, he cannot simply write a check to put it back the next year when he receives a bonus. It would take him nearly a decade of maxing out his contributions just to replace the principal he lost, without even accounting for the growth he missed during those 10 years. This is the contribution bottleneck. Once the money leaves the tax-advantaged umbrella of the 401k, it is incredibly difficult to get it back in. The step-by-step breakdown of this erosion is relentless. Step 1. The initial loss of principal through the divorce settlement. Step 2. The immediate loss to taxes and penalties if the money is taken as cash. Step 3. The cessation of compound interest on the departed funds. Step 4. The administrative fees charged by the plan to process the withdrawal. Step 5. The tax drag on any future earnings because the money is now being invested in a standard brokerage account instead of a tax-deferred 401k. When you stack these layers of economic impact, the divorce doesn't just split your wealth in half. It often reduces your final retirement outcome by 60 to 70% compared to a scenario where the marriage remained intact. We must also address the psychological economic impact, often referred to as the wealth effect. When Brian sees his 401k balance drop from $500,000 to $250,000, his consumer behavior changes. Historical trends show that individuals who suffer a massive hit to their retirement savings often become overly conservative in their investments, moving to cash or bonds out of fear. By de-risking his portfolio at the exact moment he needs growth to catch up, Brian further cements his financial loss. Or, conversely, some individuals engage in revenge investing, taking on excessive risk in cryptocurrency or speculative tech stocks to try and make up the gap quickly. In 2026, the volatility of these assets often leads to further losses, completing the cycle of retirement destruction. Another layer of the liquidity trap is the use of 401k funds for child support or alimony arrears. In many U.S. jurisdictions, a 401k can be garnished to satisfy these obligations. While ERISA generally protects 401k assets from creditors, it specifically allows for QDROs to be used for support obligations. If a spouse falls behind on payments during the emotional chaos of a divorce, a judge can order a direct hit to the 401k. For the payer, this is a double blow. They lose the asset, and they may still be responsible for the taxes on the distribution depending on how the order is drafted. This turns the 401k from a safety net into a secondary checking account for the legal system, drained by the friction of litigation. Consider the potential outcomes for those who attempt to rebuild. In 2026, the median 401k balance for a 60-year-old in the United States is nowhere near enough to sustain a 20-year retirement. When a divorce cuts that balance in half at age 50 or 55, the mathematical probability of reaching a sustainable retirement without a drastic reduction in lifestyle is nearly zero. This leads to a delayed retirement age, where individuals are forced to work into their 70s, not by choice, but by economic necessity. This has a secondary impact on the labor market, as older workers cannot vacate roles for the younger generation, creating a systemic stagnation. The 401k divorce is a masterclass in the fragility of the American retirement system. It is a system built on the assumption of stability and long-term participation. Divorce is the ultimate disruptor of that stability. By the time the paperwork is filed and the funds are moved, the structural integrity of the retirement plan is often compromised beyond repair. We have looked at the taxes, the penalties, and the loss compounding, but there is one more weapon used in the 401k wars that is even more deceptive. As we move toward the conclusion of this deep dive, we have to talk about the dark side of retirement assets. The hidden 401k. In a high-stakes divorce, not everyone is transparent about their holdings. In 2026, with the rise of fractional employment and multiple 401ks from previous employers, it has become easier than ever to hide assets in plain sight. How do you find a 401k that your spouse forgot to mention? And what happens if you discover it years after the divorce is finalized? In the next part, we are going to dive into the world of forensic accounting and the hunt for hidden retirement wealth. We will look at the lost account phenomenon and the legal consequences of 401k fraud. We will break down the search for the missing millions next. The hunt for the missing millions begins with a cold reality that defines the American workforce in 2026. The average employee now changes jobs every 4 years, and in the high-growth tech and consulting sectors, that interval is often even shorter. Each career move represents a potential fracture point in a marital estate. When a spouse departs a company, their 401k typically remains with the former employer's plan administrator, often becoming a ghost asset that is intentionally or accidentally omitted during the high-stress discovery phase of a divorce. This is not merely a clerical oversight. It is a strategic maneuver that can shift the economic balance of a settlement by hundreds of thousands of dollars. In the United States, the burden of disclosure lies with the participants, but in a litigious environment, the temptation to hide retirement wealth is a historical trend that has reached a crisis point in 2026. Imagine a case study involving a character named Andrew, a senior systems architect who has navigated the volatile job market of the last decade. Between 2016 and 2026, Andrew worked for 4 different major corporations. When he and his wife, Chloe, begin their divorce proceedings in early 2026, Andrew's financial affidavit lists only one 401k account, the one associated with his current employer, valued at $450,000. He remains silent about 3 prior accounts held at different institutions, totaling an additional $400,000. Andrew assumes that because the physical mail for these accounts stopped arriving at their shared residence years ago, and because Chloe was never involved in the household's long-term financial planning, these accounts are effectively invisible. This is the lost account phenomenon, and it creates a massive, artificial economic disparity that often leads to the non-employee spouse accepting a settlement that is fundamentally inequitable. To uncover these missing millions, a forensic accountant in 2026 does not just look at current bank statements. They perform a deep tissue audit of the marriage's entire economic history. Step by step, the process begins with an exhaustive review of 10 to 15 years of federal tax returns. The primary focus is on Form 1099-R, which reports distributions from pensions or retirement plans, but the real detective work happens within the W-2 forms. Specifically, forensic experts analyze Box 12 for every year of the marriage. If a W-2 shows a code D, it serves as an irrefutable digital fingerprint that Andrew was making elective deferrals to a 401k plan during that tax year. If Andrew claims that no such account exists today, he is forced to provide a granular accounting of where those funds went. Did he take a distribution? If so, where is the record of the tax payment? If he claims he rolled it over, where is the receiving account statement? In the eyes of the law, a missing account with a verified contribution history is a red flag that triggers immediate judicial scrutiny. The search then moves to the Department of Labor's public filings. Every 401k plan in the United States is required to file a Form 5500 annually, detailing the plan's financial condition and its administrators. By cross-referencing Andrew's employment history with these public records, Chloe's legal team can identify the exact financial institutions that managed the plans for his former employers. Subpoenas are then issued not to Andrew, but directly to the plan administrators at firms like Fidelity, Vanguard, or Schwab. These institutions have zero incentive to protect a participant's non-disclosure, and will provide a full transaction history of the account from its inception. In 2026, the historical trend shows that for every $5,000 spent on forensic accounting, an average of $50,000 in undisclosed or forgotten retirement assets is uncovered. The legal consequences for this type of financial concealment are devastating. In community property states, the court views the intentional hiding of an asset as a fraud on the community. Historical trends in recent case studies show that judges are increasingly inclined to employ the nuclear option, awarding 100% of the hidden asset to the innocent spouse as a penalty for bad faith. If Andrew is caught hiding $400,000, he may not just be forced to split it. He may lose the entire amount, while also being ordered to pay Chloe's forensic accounting fees and her attorney's fees. This is the ultimate economic backfire. By attempting to secure his future at the expense of his spouse, Andrew effectively liquidates his own retirement to fund the very person he was trying to exclude. Furthermore, we must address the role of the Social Security earnings record. In 2026, this document has become the gold standard for asset discovery. A court can compel a spouse to download their full earnings history from the Social Security Administration's portal. This record lists every employer the spouse has ever had and the exact wages earned each year. Because nearly all major U.S. employers offer a 401k as part of their benefits package, this list serves as a roadmap for forensic investigators. If a spouse worked at a Fortune 500 company for 6 years and claims they have no retirement savings from that period, the statistical likelihood of that being true is nearly zero. The economic impact of this transparency is that it eliminates the shadow of doubt, forcing a fair valuation of the marital estate. We must also analyze the forgotten IRA trap. Frequently, a 401k is not intentionally hidden but was rolled over into a traditional or Roth IRA years ago, and then ignored as the participant moved on to a new plan. Because IRAs are not employer-sponsored, they do not appear on a W-2. Finding these requires a meticulous review of bank statements to identify the specific date of a rollover deposit. In our 2026 landscape, where the rise of the gig economy and independent consulting has led to a surge in SEPARs and solo 401ks, the opportunity for a spouse to tuck away significant capital in an obscure, self-managed account is higher than ever. Forensic experts now use digital discovery tools to scan for any transfers to known brokerage firms that do not correspond with regular household spending. The economic irony of the search for hidden 401k wealth is that the very federal law designed to protect your retirement, ERISA, provides the most potent tools for its discovery and division once a legal proceeding is initiated. Privacy within a 401k is an illusion in the context of a U.S. divorce. Every contribution is tracked, every rollover is recorded, and every administrator is subject to the subpoena power of the court. For the spouse who has been left in the dark about the household finances, the discovery of a hidden 401k can change the entire trajectory of their post-divorce life. It can mean the difference between having to sell the family home or being able to buy out the other spouse's interest. The impact of discovery also ripples into the calculation of alimony and child support. In 2026, most states use an income shares model or a needs-based assessment for support. If a spouse is found to have an undisclosed seven-figure 401k, the court may determine that they have a significantly higher ability to pay support, or that the other spouse requires a larger lump sum payment to equalize their future retirement security. The hidden account is not just a pile of cash. It is a weight on the scale of justice that, when uncovered, usually tips heavily in favor of the person who is being defriended. Andrew's loss of credibility in court will likely affect every other aspect of his case, from the valuation of his business interests to his custody arrangements, as the judge adopts a stance of extreme skepticism toward his future testimony. This part of our masterclass illustrates that the economic impact of a 401k divorce is often determined by the transparency of the participants. In 2026, with consolidated financial data and robust forensic techniques, hiding a 401k is a high-risk gamble with a low probability of success and a high probability of total financial loss. The search for the missing millions is a process of reclaiming the economic partnership that a marriage is legally defined to be. But even when all the accounts are found, and the QDROs are signed, and the taxes are paid, a massive question remains. How do you recover from the structural damage done to your retirement timeline? If you lose half of your life savings at age 50, is it even possible to rebuild a seven-figure nest egg in the current U.S. economy? In our final part, we are going to dive into the 1,000-day recovery roadmap. We will look at the mathematical reality of catch-up contributions, the strategic use of HSA accounts to supplement retirement, and the long-term outlook for the millions of Americans who are reinventing their financial futures after a 401k divorce. The masterclass concludes with the blueprint for your financial resurrection. The financial resurrection after a 401k divorce in 2026 is not a matter of luck. It is a matter of mathematical discipline and the aggressive exploitation of the tax code. We have spent 9 parts of this masterclass dissecting how wealth is destroyed, hidden, and taxed during a split. Now we shift our focus to the 1,000-day recovery roadmap. This is the critical window where a newly single American can either stabilize their trajectory or drift into a permanent retirement deficit. Historical trends suggest that the first 3 years post-divorce are the most volatile, as individuals often struggle to transition from a two-income mindset to a single-account reality. To rebuild, you must move beyond the emotional trauma and start thinking like a distressed asset manager. Imagine a case study involving a 52-year-old marketing director named Samantha. After her divorce in early 2026, her 401k balance was cut from $1.2 million to $600,000. She kept the family home, which has significant equity but carries high property taxes and maintenance costs. Samantha is now facing a 25-year horizon until she reaches age 77, yet her retirement engine has been halved. The first step in her 1,000-day roadmap is the immediate maximization of the catch-up contribution. In 2026, under the provisions of the Secure Act 2.0, the landscape for older savers has shifted significantly. For those aged 50 and over, the standard catch-up limit allows for an additional $7,500 to $8,000 on top of the base contribution limit of $24,000. This means Samantha can funnel over $32,000 a year into her 401k. Over 1,000 days, that is nearly $100,000 in principal alone, not counting employer matching or market appreciation. However, there is a hidden mechanism in 2026 for those aged 60 to 63. The law now allows for an enhanced catch-up contribution of $10,000 or 150% of the standard catch-up, whichever is greater. If Samantha stays the course by the time she hits 60, her ability to compress her savings timeline increases exponentially. Step by step, the goal is to shift the savings rate from the typical 10% to a hyper-aggressive 30 or 40%. To do this, Samantha must engage in what we call lifestyle right-sizing. This is the painful process of evaluating the family home. If she is living in a 4-bedroom house alone, the economic impact of the maintenance, utility, and tax drag is effectively stealing from her 401k recovery. Selling the house and moving into a high-efficiency condo could free up $2,000 a month in cash flow. That $24,000 a year, when redirected into a tax-advantaged account, is the fuel for her financial resurrection. Next, we must analyze the Stealth IRA, also known as the Health Savings Account or HSA. In 2026, the HSA remains the most powerful and underutilized recovery tool in the American financial arsenal. For a single person, the contribution limit is approximately $4,300. It offers a triple tax advantage. Contributions are tax-deductible, growth is tax-free, and withdrawals for medical expenses are tax-free. But the masterclass move is the shoebox method. Samantha pays for her current medical expenses out of pocket, keeps the receipts in a digital shoebox, and allows the HSA to stay invested in low-cost index funds. 10 years from now, she can reimburse herself for all those past expenses using the tax-free growth. If she doesn't need it for medical costs at age 65, the HSA functions exactly like a traditional IRA. where she can withdraw funds for any purpose, paying only ordinary income tax and avoiding the 20% penalty. For a divorcee rebuilding a nest egg, the HSA represents an additional $4,000 to $5,000 of tax-sheltered growth every year that can hedge against the rising cost of healthcare in retirement. We also have to address the strategy of tax bracket arbitrage. Many people in 2026 find themselves in a lower tax bracket immediately following a divorce because they are no longer filing jointly with a high-earning spouse. This is a unique, short-term window to perform Roth conversions. If Samantha's income has dropped, she can move portions of her remaining $600,000 traditional 401k into a Roth IRA. She pays the taxes now at her lower individual rate, and the money then grows tax-free for the rest of her life. This eliminates the tax time bomb we discussed in Part 3. Historical trends show that those who diversify their tax buckets post-divorce are much more resilient to future changes in federal tax law. The 1,000-day roadmap also requires a total reevaluation of investment risk. After losing half of an account, the natural impulse is to de-risk and move to cash to protect what is left. This is a potential outcome that leads to long-term failure. To recover, Samantha needs the growth that only equities can provide. However, she no longer has the safety net of a second income. A 2026 recovery strategy involves a barbell approach, keeping 2 years of living expenses in a high-yield cash account or short-term treasury bills to avoid selling stocks during a downturn, while keeping the remainder of the 401k aggressively invested in diversified total market funds. This allows her to participate in market recoveries without the paralyzing fear of a total wipeout. The psychological economic impact is just as critical as the math. In the first year of her recovery, Samantha must resist the urge to use her remaining 401k as a source of emergency funds. This is why building a secondary, non-retirement emergency fund is step 0 of the resurrection. If she hits a car repair or a medical bill and has to dip into the 401k, the cycle of taxes and penalties begins again, and the 1,000-day clock resets. The data is clear. Those who treat their 401k as an untouchable fortress are the only ones who successfully rebuild. We must also look at the longevity risk and the Social Security delay strategy. Because her 401k is smaller, Samantha cannot afford to retire at 62. Every year she delays claiming Social Security between age 67 and 70 increases her monthly benefit by approximately 8%. This is a guaranteed increase that outperforms almost any other investment. By working until 70, Samantha gives her 401k another 18 years to compound from age 52. If she achieves a 7% return, her $600,000 could grow to over $2 million by the time she stops working, even if she never added another penny. When combined with a maximized Social Security check, her standard of living in her 80s could actually be higher than it was during her marriage. The potential outcomes for the 401k divorcee in 2026 are not universally bleak. While the split is a trauma, it is also a forced audit that can lead to a more efficient and intentional financial life. The resurrection is built on the pillars of maxed-out catch-up contributions, strategic HSA usage, Roth conversions during low-income years, and a patient, long-term approach to Social Security. The economic impact of the divorce is a permanent scar, but it does not have to be a permanent disability. You are now the sole CEO of your financial future, and the 1,000-day roadmap is your first board meeting. As we conclude this deep dive masterclass, you now have the full picture of the 401k divorce crisis in America. From the legal traps of the QDRO to the invisible fees of the plan administrators, and finally to the blueprint for recovery, you are equipped with the knowledge that most people only gain through expensive failure. But the world of retirement finance is shifting even as we speak. While we have focused on the 401k, a new battle is brewing over the very existence of the private pension and the future of the Social Security Trust Fund. How will these looming changes affect your newly rebuilt nest egg? What happens when the government changes the rules on Roth accounts in 2027? And is there a way to shield your 401k from the next global economic reset that experts are already predicting? The 401k divorce was just the beginning of the story. In our next series, we are going to dive into the great retirement reset of the late 2020s and the specific strategies high net worth individuals are using to move their wealth entirely out of the reach of both the taxman and the courtroom. The war for your wealth never ends. It only changes fronts. We will see you in the next deep dive.